Good afternoon. My name is Susan Brody. I'm the Associate Dean for Academic Affairs here at the John Marshall Law School. Dean Johnston regrettably could not be here today to welcome you himself, so I have the honor in his place. Welcome to the 10th Annual Media Law Symposium. I'd like to start out by giving special thanks to Baker McKenzie, who provides the funds for us to continue this program each year. The purpose of this symposium is to discuss issues of national importance to both the legal and journalism professions. I think it's especially exciting to welcome you to this particular symposium at this particular juncture in John Marshall Law School history. In 1999, we will be celebrating our centennial birthday. And as we prepare for that, we've had an opportunity over the past year or two to reminisce a great deal. We've also had an opportunity to look forward to our future, to look forward to some exciting new developments that will help us continue the opportunity for the kind of interdisciplinary exchange that this program has provided for us. Most exciting, I think, and most related to this particular program is a new LLM program that the law school will be beginning in January of this year. Beginning in January and under the direction of Professor George Trubeau, we will be admitting students for an LLM program in information, technology, and privacy law. As those areas develop and as they become more global, the media, of course, becomes a critical part of the discussion of technology, information, and privacy. To that end, the new program will bring together law, technology, privacy, and information, and give us greater opportunities to discuss those matters and to educate people who will be in the journalism and legal professions of the future. This program here today symbolizes our opportunity to discuss those topics. Past speakers have included both Bill Plant and Bill Curtis from CBS, Andrew Barrett, a commissioner from the FCC, Alan Sears, the executive director of the Meese Commission, and Philip Friedman, the novelist. This year's program is All Fair in Love and War and Newsreporting, will feature Lynn Sweet, the Chicago Sun-Times Washington Bureau Chief, Bernard Judge, the editor of the Chicago Daily Law Bulletin, Sandra Davidson, professor of journalism at the University of Missouri, and Michael Polelle, professor of law here at the John Marshall Law School. Finally, to introduce these people in more detail to you, I'd like to introduce to you Professor Alberto Bernabe, who will be moderating the program. Professor Bernabe teaches media law and ethics here at John Marshall. He's extremely well-versed in the topics that will be discussed today. His most recent article, Prior Restraints on the Media and the Right to a Fair Trial, a proposal for a new standard, was published last year in the Kentucky Law Journal. I introduce to you Professor Alberto Bernabe, who will moderate the program and introduce the speakers. Thank you.
Thank you, Susan, and welcome again to our 10th Annual Media Law Symposium. I just recently returned from a communications law conference in New York, and I was surprised once again that for the last 2 years, the discussion in that media law program, which is created and run by attorneys and for attorneys, turn out to be more on ethical issues of the ethics of journalism and the practice of journalism. And I think this has happened because of recent developments in the practice of journalism that have led to other developments in legal matters. We have seen recently the rise of what some people call the in-your-face type journalism. We have seen the rise of the news magazine programs of different levels in the tabloid scheme, if you want. And we have also seen the rise of the ride-along shows where the media goes along with police or rescue teams and usually tape live footage of people in trouble or people getting arrested. We have also seen developments in technology that allow the press to get information in ways that were not available as recently as a decade ago. We have powerful lenses that allow photographers to take pictures from really far away. We have cameras don't need outside lighting, they can be concealed, and we have recording devices that have much more clarity, even if concealed when used. All of this, I think, has led to the possibility of the press getting information from people who don't know that they are providing information to the press and who may not want to be given information from the press. Is that fair? That's one question that we have to think about. However, this is not new, really. Getting information from people that don't know that they're giving information is not new. We can find examples of surreptitious journalism, if you want to call it that, even way back in the 1930s when the first picture of an execution taking place was published, which was, the picture was taken by a photographer with a concealed camera in the execution chamber. What I think is new is two things. I think that the type of information that the press is trying to get these days is different, perhaps, from the type of information that we were publishing a few years ago. And some people might question that a lot of information that we get in these programs and these type of new journalism is of questionable news value. And also, some other people question whether it is being sought simply because of economic competition for better ratings or more readers. The other thing that is new is the legal aspect of journalism, the media law aspect of journalism, and particularly the rise of the tort of intrusion, which was basically unknown until just a few years ago, and now has become one of the most commonly used by plaintiffs against the media for compensation for damages. The question is usually whether the media should be responsible for intrusions into the privacy of the plaintiffs, even though the information that eventually gets obtained is true, is not defamatory, and may or may not be newsworthy. Two examples to start the hypotheticals going. Compare the cases of a photographer in Florida who hired a helicopter to fly over Steffi Graf's home to be able to photograph her while she was sunbathing nude in her backyard, with the case of a newspaper that I used to represent in Puerto Rico, which hired a helicopter to fly over the home of a legislator who is married to a federal judge to document a story reporting that they had moved their fence to take over some property of a public park. The way in which this type of information was acquired is exactly the same. Is all fair? Are the information, both these cases the same or not, becomes a question of newsworthiness and of ethical journalism that we ought to consider. To finish, let me just point out a recent case in the Seventh Circuit where Judge Posner, in an opinion dismissing a cause of action for intrusion, stated, and I will quote, that there shouldn't be a cause of action against the press in that case because any person of normal sophistication would expect a journalist to break their promises. And Judge Posner added, if that is fraud, it is the kind against which potential victims can easily arm themselves by maintaining a minimum of skepticism about journalistic goals and methods. Now, I think today we will address this issue. I think today we will address the question of whether we should expect journalists to lie and whether that is a good thing or not. And I think we have the great opportunity to explore the issue from very different perspectives. We will have the perspective of the law professor, the perspective of a journalist, the perspective of the journalism and ethics professor, and the perspective of a publisher. We want to ask ourselves, what are the ethical implications of journalist practices today and how they should relate to the function of the press in a democratic society, which, at least in theory, the freedom of which is based on a free press that is not only expected to, but encouraged to go out there and get the information. I'd like to introduce all the speakers, and then they will make presentations, and then we will have some discussion at the end. Our first speaker is a good friend, and he's no stranger to John Marshall. He is Professor Michael Polelle. After teaching at the Paul Law School for a number of years, Mike joined the faculty of John Marshall in 1975 and has since taught courses in torts, evidence, media law, and the First Amendment. He has served as Special Assistant State's Attorney for Cook County and as a reporter to the Illinois Judicial Conference on many occasions. He has published numerous articles in the areas of torts and First Amendment law, and is the co-author of one of the, if not the most important, treatise in Illinois tort law. Mike is the director of our annual Media Law Symposium, which, as you have heard, is now in its 10th year. And I must say, in all honesty, that it's really because of his enthusiasm and hard work that this Media Law Symposium can be brought to you every year, and every year since it started. Our second speaker will be Sandra Davidson. She is an associate professor of journalism at the University of Missouri, where she also teaches at the School of Law. She obtained a PhD in philosophy with emphasis in social and political theory and ethics at the University of Connecticut. Ms. Davidson has participated in many panels on journalism and has published several law review articles on torts actions against the media, access to information, and has an article that will be published soon on censorship. I think Ms. Davidson will probably be able to speak to us from very different perspectives that I find very interesting. The perspective of an ethicist with background in philosophy, the perspective of a professor of journalism, which I hope includes creating in her students a sense of ethical practice of the practice of journalism, and also from the perspective of a practicing attorney, since she represents the Columbia Missourian, a newspaper published by the School of Journalism. Our third speaker will be Lynn Sweet. First of all, I would like to welcome her back to Chicago. She is currently the Washington bureau chief for the Chicago Sun-Times. She began her journalism career in Libertyville, Illinois, working for the Independent Register, and she joined the Sun-Times in 1976. Before moving to Washington, she, at the Sun-Times, worked as a political writer covering numerous political campaigns and the civil courts. She recently became one of the first reporters to write about the questionable campaign fundraising issues, and which, as you know, has become one of the important topics of the day. Finally, we will hear from Bernard Judge, who is the editor of the Chicago Daily Law Bulletin and the Chicago Lawyer magazine. He served in management positions for both the Chicago Tribune and the Sun-Times for over 30 years. He joined the Tribune in 1966, where he covered criminal cases, the federal courts, and state politics. And he, in the early 1980s, moved to the Sun-Times, where he served as associate editor until 1988. Mr. Judge has been a journalism professor at the Medill School of Journalism of Northwestern University. And I hope that he will present the point of view of the publisher and the journalist also. So I will come back to moderate the question and answer period after the presentations of our speakers, and I hope you all can stay and write down your questions, and we can have some lively discussion.
Well, I want to thank you, Alberto. And one of the things I've learned being a director for 10 years is that it's good to have competent people you can delegate things to. And Alberto has certainly helped out immeasurably in running this conference together with my colleague Doris Lynn. So I want to thank you, Alberto, for all the help you've given us. Today's topic is all fair in love, war, and news reporting. is a topic that occurred to me when I first joined the Media and Law ISBA, Illinois State Bar Committee. I think it was the first committee where lawyers actually got together with non-lawyers. That was considered kind of radical at that time, to have a law committee with non-lawyers, especially people called journalists. And it turned out to be one of the most useful committees I've ever been on in terms of give and take between issues that affect both our professions. Is all fair in love, war, and news reporting occurred to me around 11:30 at night one time. And it occurred to me that there are limits, although we may differ as to what they are. In love, we no longer allow slashing of tires or assassinations. In war, since the Geneva Convention, we prohibit mass rape, we prohibit destruction of cities, and we try to punish, as we see going on in Bosnia. And so I would assume that there are some limits. The question is, what are those limits in news gathering? I would like to focus on two cases, Food Lion versus ABC and Berger versus CNN. And then I'll just give you a few of my reflections before I pass on the torch to the other speakers. Food Lion versus ABC involved a case arising in the Northern District of North Carolina, federal court, in which Primetime Live, ABC, got a tip from some ex-employees that the Food Lion stores were selling spoiled food. Now, the parties who made the complaint had some labor dispute with Food Lion. But they also said that you better watch the managers, that the managers are around all the dumpsters at night taking out spoiled food. And the allegation was that there was rat-gnawed cheese, which was being reused, chicken, smelly chicken, which was being scraped and then slathered with barbecue sauce to get rid of the smell, and that the date sold labels didn't mean anything at Food Lion. In order to check this out, Primetime Live sent two reporters undercover, Litt and Barnett, and they constructed completely fabricated resumes in order to get a job at Food Lion in the spring of 1992. They had cameras hidden in their rigs as they were going about their activity, taking pictures of what was happening at the Food Lion. They took more than 50 hours of hidden camera footage, about 5 to 10 minutes of which was used in the 26-minute show in November 1992. Food Lion did not sue in defamation. This is important for this case. Part of their allegation, though, was that had ABC complied with discovery, they would have been able to find information to sue for defamation. But the judge concluded that in any event, there was no case for defamation that they had been able to allege. So what they relied on, after trying all kinds of exotic theories, were fraud, trespass, breach of employee loyalty. What the court settled upon was the fact that whatever could be recovered would not include publication damages. As you can imagine, when news leaked out to the public what was being done at Food Lion, people preferred to buy their cheese and chicken at other stores. And so Food Lion alleged that they lost $2.5 billion. The judge said, we're not going to let you sue for that because what you're trying to do is perform an end run around defamation law. Under New York Times versus Sullivan and Gertz, you would have to prove actual malice in a defamation case. And since you're suing for publication, we feel that the only legitimate tort to be able to sue for would be defamation. That the Supreme Court in Hustler has said that if a lawyer is trying to sue with intentional infliction of mental suffering, for example, to evade the restrictions on defamation, the Supreme Court would not allow it. It would require actual malice. So that was a crucial decision because it cut off the greatest possibility for damage recovery, all the harm caused by publication. What went to the jury, however, was fraud and trespass and breach of employee loyalty. Now, Food Lion said, well, there were some staged incidents where the employee set up situations and then took photographs of it. And the court said, well, if you could prove that, then we would allow you to recover publication damages because that would be false if they staged the incidents. But most of those, fortunately for ABC, ended up on the cutting room floor. There were only 4 incidents where the employees arguably had staged incidents and then photographed them. And the court said, well, those were typical of what other employees were doing, so they weren't really that false. What ultimately happened is the jury awarded only $1,400 for fraud, the cost of training these employees and then hiring new employees. And when the 2 employees quit, they stayed for about a week and gave false reasons for why they were leaving. And then $1 each for trespass and breach of loyalty. However, the kicker was $5.5 million in punitive damages, which the judge I see recently has reduced to $315,000. Now, I think it's doubtful that that $315,000 is going to stand up given the Supreme Court's decision in BMW of North America versus Gore, because the punitive damages are 225 times the compensatory, even as reduced. Now, in the BMW case, they were 500 times. So it's a question, is 225 times compensatory too much or not? But even more importantly, the court notes that there was no equivalent verdict in North Carolina for a civil judgment anywhere near that amount for fraud. And the Deceptive Practices Act of North Carolina only allows a trebling of damages, which would be $4,000 approximately. So there's a good chance that this punitive damage award will be cut even further on appeal. Now, the Berger case, CNN, involves not only undercover activity, but undercover by the media working hand in glove with the government. And what I'm about to say was reported rather extensively in the Wall Street Journal of September 25, 1997. The United States received word, the U.S. District Attorney, that there was a problem with bald eagles dying of poison. The ranchers out west would poison their sheep in order to kill predators such as coyotes, and the bald eagles were ingesting the poisoned meat and dying. And the United States Fish and Wildlife Service wanted to conduct a public relations campaign, which coincided with the aims of the U.S. Attorney in that area, who wanted to make an example of a rancher who was engaged in this activity. So working together with CNN, a raid, a search warrant, and arrest warrant was issued against Paul Berger, 72-year-old with no criminal record, who owned 75,000 acres in Montana. There was a tip that the U.S. Fish and Wildlife Service had received that he had poisoned eagles to stop them from killing his sheep. The U.S. Attorney got out the word to CNN that he would like CNN to come along. And CNN agreed. In fact, the host of the CNN show, Earthwatch, reported internally that there was a huge cache of illegal poisons on the farm and that the ranch was a graveyard for bald eagles. So at dawn, the raid occurred with 21 men descending on the ranch with weapons, a caravan of trucks, and a surveillance airplane overhead. 3 of the 21 looked like agents, but were really CNN employees. The agents of the government were wired to a special feed into the CNN tape. The local sheriff had no idea what was going on. He got a call from the Bergers. When he went out there, he ordered the CNN employees to leave. On tape, Berger was shown confessing to spiking sheep to kill the coyotes, which he claimed killed 400 of his 5,000 sheep every year. But the search found no poison eagles. There were only 2 poisoned sheep carcasses, a skunk, a hawk, and a gull. And a later search was conducted by airplane surveillance, which could find no poisoned eagles. Nonetheless, the U.S. Attorney brought charges based on the word of the ex-employees for the death of 17 bald eagles. The jury acquitted Mr. Berger of all counts except the misdemeanor of spiking sheep with poison. Now, in the closing argument, as reported by the Wall Street Journal, the U.S. Attorney said this to the jury as to why investigators had refused to let neighbors comfort the elderly Bergers during the 10-hour search. He said this to the jury: "Neighbors are not allowed in when you are executing a federal search warrant. My wife wouldn't be allowed in. You don't want anybody else running around. What he hadn't mentioned, and the judge didn't allow the jurors to know, was that 3 CNN employees were the guests of the U.S. Attorney. When he found out about this, as you might expect, Mr. Berger was upset and filed suit based on a violation of civil rights. And there are Supreme Court cases indicating that where private employees work private citizens work hand in glove with the government, they can be sued along with the government for violation of civil rights. And he pointed out that there was nothing in the search warrant that authorized CNN to participate, and that the warrant expressly excluded search of the house. Because after all, they're talking about poisoned eagles. And yet the tapes, ironically, showed the agents making a search of house, according to Mr. Berger. The Justice Department manual expressly prohibited the use of media personnel together with the search. CNN's defense was that the federal agents were possessors in control, but ultimately they relied on the First Amendment. That, quote, investigative journalism is an important part of today's television, is entitled to all the safeguards of the First Amendment. Now, I understand from the latest computer search that the trial judge did give a summary judgment for CNN, as I understand it, but I'm sure this isn't the last of the case. CNN did produce the show called Ring of Death, 12 Minutes, which quoted investigators as saying the evidence confirmed their worst suspicions. As for the explanation of the verdict, the host of the show said that this reflected the bias of Western judges and juries who were sympathetic to ranchers. Now, what I'd like to just reflect on this for a minute and the implications of these cases. First of all, it's solid constitutional law upheld numerous times by our Supreme Court. The generally applicable laws do not offend the First Amendment just because their enforcement against the press has incidental effects on the ability to gather news. The court has upheld numerous times the fact that antitrust laws, labor laws, gender discrimination laws, zoning laws, fire protection laws, even sales and use taxes on printing presses are constitutional, as long as they do not pick out the press for special treatment. In fact, in the Cohen case, the court held that a reporter at a news agency was responsible for violating its promise not to reveal the source of information under standard contract law principles. So if, in fact, that is true, I have a problem as to why tort law should be treated any differently, why the normal torts that would be applied against a private citizen should not apply against the press. The second point I want to make is that we are not talking about the actual reporting. We're talking about gathering the information. And that is where the court itself, the U.S. Supreme Court says, quote, in Brandsburg versus Hayes, it has generally been held that the First Amendment does not guarantee the press a constitutional right of special access not available to the public generally. So the press has been excluded from getting passports to Cuba, where private citizens could not get such passports. The press has not had the right to investigate crimes or disasters where the general public is excluded. There's no special right of the press to investigate prisons or inmates beyond that afforded to the general public. And Texas was upheld, at least the Supreme Court denied cert, when Texas banned cameras and tape recorders from being brought into execution chambers, where that ban was applied to everybody equally, media and non-media people. Now, there are a couple of theories floating around in the academic world that it seems to me challenge these principles of law. And one is the notion in the literature that there should be a qualified privilege for reporters to commit what otherwise would be torts, civil wrongs, if committed by private citizens, as long as it's in the public interest. Now, I'm a little leery about this, the public interest. For example, if you read the new biography of Colonel McCormick, one of the quotes used by the author, Richard Norton Smith, was the quote by Colonel McCormick is that I like to stir up the animals. It's a quote. And what he meant is he likes to create controversy. And what it raises this question, is the public interest identical with that of the press? Or to put it another way, many years ago, an official of General Motors said what is good for General Motors is good for America. should the press define what the public interest is, or should governmental officials? And it seems to me we have a problem, because the press properly is not elected by government. Like government, it can't be voted out of office. It is certainly not licensed. It would be a violation of the First Amendment to do so. It has no uniform canon of ethics by which its members are disciplined, unlike medicine and law. Newspapers and media, the Supreme Court has noted, run the risk of becoming monopolies in certain markets. The Supreme Court has said there is no right to reply to accusations made by a newspaper in the columns of that newspaper. And recently, with a little help from the courts, our legislature and Congress has abolished the fairness doctrine, which required television and radio to give both sides of a controversy. So I'm a little leery about letting the media decide what's in the public interest. For example, in the ABC case, would there have been any? Why didn't ABC report the problems it found to law enforcement authorities? Some 7 or 8 months went by until ABC ran its report. Well, I think the answer is obvious, that ABC in our economy has a duty to investigate, but it does not consider itself as a law enforcement agency. But it raises again the question, that can we rely on the media to define what the public interest is? Now, it seems to me that the problem is, if you say that these torts should be ignored when the media is involved, what about crimes? If you use illegal wiretaps, it's not only a tort of invasion of privacy, but in many states it's a crime. Now, how can it be that the media should be liable for a crime but not for a tort? I don't understand, because the crime is the more serious evil. Unless we're going to say the media should be exempted from both prosecution for a crime and the tort. If we do that, it seems to me that's a very serious step. Is the branch, the argument in the academic world has been that by many in the academic world, is that the press is really like a fourth branch of government, and that the press and the media generally should have more rights, if you will, under the freedom of press than the ordinary citizen has under the freedom of speech clause in the First Amendment. Now, the problem, I think it's a good theory, but the problem is, look what can happen. If the press works hand in glove with the government, what is the checking function of the press on government? Where we have the press and the government working together. In fact, it seems to me this will simply make the public more cynical about any credibility by the press when it works in cooperation with government. Now, a final point I just would say, it seems to me the difficulty is in both the professions of journalism and law suffer, as we know, from low public esteem. If we exempt the press from the normal laws that apply to ordinary citizens, I think this will have a very adverse impact on the press. For example, to do my research for today, I took the time out to see Mad City. How many of you seen Mad City? Okay, it's not a very flattering portrait of the media. And consider that in 1981, I think Absence of Malice was a very good balanced account of New York Times. And it put the media, at least in an understandable way. And I think if journalists are not careful, they may run the problem in the media that we as lawyers have, when you stop to think of how the legal profession is portrayed, from the heights it had in To Kill a Mockingbird. So I thought that film was very revealing. And there's one scene I want to end with. It's the scene where Dustin Hoffman is trapped in this museum, and he sees a hostage situation going on. And somebody got shot. And somebody says, you ought to call the police. And he says, not now. We don't want to call the police. We have a media opportunity here. And that, it seems to me, is the problem that I think the press should be concerned about. That if, for example, the press, I want to end with this example. The press pretends to be two investigators pretend to be phone repair persons in order to gain access to the apartment of suspected Watergate burglars who are accused of stealing documents. Isn't that a little contradictory to say that the press should engage in the very kinds of activities that is investigating as illegal? And that, I think, will lead to general public cynicism. And I hope we don't arrive at that day. Thank you.
So as Michael told you, low public esteem is something that journalists have to worry about. Now, when I go off campus, I really don't know whether I should say that I'm teaching budding journalists or budding lawyers. And have you noticed that the lawyer jokes are just as funny if you substitute the term journalist? Well, as Michael mentioned, the United States Supreme Court has gotten involved. It's gotten involved in saying that journalists do have responsibilities. Michael mentioned Cohen versus Cowles Media. You promise confidentiality, you burn your sources, and the Supreme Court says, then yes, you can face the music in terms of contract law. How about telling the truth? Same year as Cohen versus Cowles Media, 1991, we get a big case, Mason versus the New Yorker magazine. This is one of those he said, she said soap operas. It stars Jeffrey Mason, who is a psychoanalyst, who became disillusioned with Freudian psychology at a time when he was serving as projects director of the Sigmund Freud archives in London. Oops, he got fired. Janet Malcolm decided to write a story about him. She invited him, in fact, to live with her for a while. She had a background. She had written for the New Yorker that, quote, every journalist is a kind of confidence man preying on people's vanity, ignorance, or loneliness, gaining their trust, and betraying them without remorse. Then she taped roughly 40 hours worth of conversations with Mason, and she wrote her articles. Did Mason really say, among other things, that the superiors at the Sigmund Freud archives considered him an intellectual gigolo? You get your pleasure from him, but you don't take him out in public. Intellectual gigolo, a nice phrase. Well, the tape recording shows that what he said was, I was, in a sense, much too junior within the hierarchy of analysis for these important training analysts to be caught dead with me. Intellectual gigolo? Maybe it's like one judge said, well, if it wasn't said, maybe it should have been. So do you go with it? Well, the Ninth Circuit was going to be very lenient with journalists. The rational interpretation standard, saying that malice will not be inferred from evidence showing, I'm quoting, that the quoted language does not contain the exact words used by the plaintiff, provided that the fabricated quotations are either rational interpretations of ambiguous remarks made by the public figure or do not alter the substantive content of unambiguous remarks actually made by the public figure. So, rational interpretation was, first question, I guess, was Mason a public figure? He said, yes, I don't know about his id, but he certainly did have a big ego. The Supreme Court, though, when it got this case, said that no, it was not okay to have fabricated quotes. I think the United States Supreme Court was trying to protect the sanctity of quote marks. And in striking down rational interpretation, here's what the court said. Were we to assess quotations under a rational interpretation standard, we would give journalists the freedom to place statements in their subjects' mouths without fear of liability. By eliminating any method of distinguishing between the statements of the subject and the interpretation of the author, we would diminish to a great degree the trustworthiness of the printed word and eliminate the real meaning of quotations. Not only public figures, but the press, doubtless, would suffer under such a rule. If you see it in quote marks, what do you think? Don't you think that it actually came out of the speaker's mouth? Well, I enjoyed this 1991 decision. 1993, the Supreme Court let stand a case which has got importance to advertisers. And remember that advertising is the lifeblood of journalism. This was the Braun versus Soldier of Fortune case, a $4,375,000 judgment against Soldier of Fortune, which had run this little ad. I quote, gun for hire, 37-year-old professional mercenary desires jobs. Vietnam veteran, discreet, misspelled, and very private. Bodyguard, courier, and other special skills. All jobs considered. an ad put in the magazine by a man with the apt name Michael Savage. Then on a hot August night, Richard Braun and his son were backing down their driveway in the car when three thugs unloaded with Mac 11s. Both men in the car were hit. The father rolled out of the car. One of the thugs pumped 2 bullets in his head. The son survived. The 2 sons sued for negligence. There was a foreseeable risk of harm that an assassin would be hired. The assassin was hired $4,375,000. Soldier of Fortune, by the way, said, "We can't pay the judgment. Would you like the magazine?" The son said no thanks and settled for a lesser amount of money. And this is not a surprising case in terms of law. In fact, the first big negligence case started in my hometown of Columbia, Missouri. Supreme Court let this decision stand also in 1983. Another hot August night. Sandra Hyde had just gotten through dancing at a disco. She was walking down Broadway, a major road in Columbia, late at night, when a red-headed man driving a red Mustang, he had a red beard, red mustache, and a sawed-off shotgun pulled alongside her and said, "Get in, or I will blow your brains out." She got in, obviously. He turned the corner. She jumped out. She kept running, even though he grabbed her dress. It ripped. She got back to the disco. She called the police. She filed a police report. She gave her name and address. 2 facts that the red-headed assailant did not have until he read them the next day in the Columbia Daily Tribune. And then I guess you can imagine what happened. She saw him that night in front of her house. He put the shotgun on top of his car and looked her way. Then she started getting these pleasant little calls saying like things such as, "I'm glad you're not dead yet. I have plans for you before you die." Bottom line, Missouri courts did not accept a public records defense. The Missouri court said negligence, a foreseeable risk of harm. This case was also followed in 1988 in California, a Times Mirror case. Again, it was a public records defense put forward when a summer intern had gotten the name of a woman who had gone home to her apartment, found the nude, dead, beaten, raped body of her roommate and an assailant. She got away. The assailant did not know who she was until he read it in the LA Times. Negligence, an area of the law that we wouldn't have been talking about, say, 15 years ago. Now, privacy, another area, as you've already heard, that is certainly rapidly taking shape as one of the major areas of concern to journalists in terms of avoiding damages. Heightened concerns. I think computers in general have heightened the concerns of people for their privacy. How many of you get these pestiferous calls in the evening, especially at dinner time, and you know that people know a little bit more about you than you would like? That's one concern. The other, been just a few terribly bad examples. For instance, when Robert Bork was trying to be seated on the United States Supreme Court, a weekly newspaper in Washington, D.C., the City Paper, got a hold of his video rental records, 146 of them. The next year, unanimously, Congress passed the Video Privacy Protection Act. Now you need a court order to get a hold of those. And then, of course, when Clarence Thomas was up for confirmation, we would have wanted those video rental records to see if maybe any of them starred a Mr. Silver. And, of course, there was Arthur Ashe. 1992, Arthur Ashe, the tennis star, a very beloved person, who got a call from a USA Today reporter who revealed that the newspaper would tell the world that Arthur Ashe had AIDS. and Arthur had to tell his young daughter that he was going to die at a point in time when Arthur had not wanted to do so. On the other hand, Arthur Ashe put a new face on AIDS. Arthur Ashe was the victim of a faulty blood transfusion, while he had heart surgery. Then we had the media asking, fair game? Well, that's a question. Newsworthiness has been the powerful defense in this area. It's been kind of a circular reasoning that's prevailed. You can use it if it's newsworthy. What makes it newsworthy? If journalists want to use it. So we're on a roll. But since about 1985, we've seen a watershed. 1985, one Oregon case, Anderson versus Fisher Broadcasting Company, the court said, well, we're not sure that invasion of privacy really even exists. A 12-year survey showed no hits. But now we have seen a cracking of that. The Restatement Second of Torts is a major test used, and it says that one who gives publicity to a matter concerning the private life of another is subject to liability to the other for invasion of privacy if the matter publicized is of a kind that first would be highly offensive to a reasonable person, and second, is not of legitimate concern to the public. So it can be highly offensive, but it's still okay if it's legitimate news concern. Well, we've had a couple of interesting cases in this area. I'll mention one that comes again from my home state of Missouri. This is YG versus the Jewish Hospital. Here's what was happening. Jewish Hospital had a very successful in vitro fertilization program. Now, is that newsworthy? Highly newsworthy. Jewish Hospital decided to throw a party to celebrate successful in vitro fertilizations. So a woman showed up, 5 months pregnant with triplets, that's quite pregnant. The KSDK TV reporters who were there wanted to interview her. She said no on several occasions, but still, there she was, 10 o'clock news. Her name wasn't given, but for 3 seconds she was there, and she was unmistakable to people who knew her. Then she started getting calls. She belonged to a fundamentalist religious group that thought that pregnancy should be an act of God, thank you, no help from mankind, of in vitro fertilization sorts. What Missouri said was this: in vitro fertilization is highly newsworthy. The fact that this one woman was pregnant that way was not newsworthy. I mentioned one other tort, outrage. Outrage. This is what happened in Florida in 1991. Regina May Armstrong, a little 6-year-old, had disappeared. She was wearing a little sundress. A year or so later, a construction worker found a tattered sundress and a skull. Finally, the authorities figured out that it was Regina May Armstrong, and on the day of Regina's memorial service, an enterprising reporter from Channel 2 went down to the police station, the Oviedo police station that's near Orlando, and asked to see the skull. So the police chief got the skull out of a shoebox, held it up, and she said, "That's nice, would you do it again?" So he did, and she got this tilted zoom-in close-up. She took her tape, she called back to the news office, and a couple of the people said, "Oh, I don't think we want to do this," but the news director, Mr. Sensitivity, had the final call. He said a 4-letter word, and they said, "We'll use it." He had not seen it. That night, 6 o'clock, the Armstrong family is gathered around the TV. So we have the coverage of the memorial service and pictures of little Regina May, the way she was in life. It switched to animal bones that had been mistakenly identified as her remains, and then it ended with this zoom-in, tilted shot of the little girl's skull. The family had not been forewarned, and the 12-year-old sister went screaming out of the room saying, "This cannot be my sister," and the family sued. And the court said, outrage. If this isn't a case of outrage, then the tort doesn't exist. But it does exist if someone has crossed the bounds of decency that a civil society can allow. Well, as far as these cases have gone with hits, we've still had a lot of instances. For instance, when a pressman was killed by an AK-47 in Louisville, Kentucky, a picture of this man, Richard Dickey Barger, was on the front page of the Louisville Courier-Journal. He was lying across a conveyor belt, either dead or dying. Kentucky Appeals Court said, well, this is newsworthy, and the Supreme Court let that stand. So yes, we can still do quite a bit as journalists. Where are the lines? Well, we've had some interesting cases. We've talked about prime time. January 1997, a $1.2 million judgment was overturned. Primetime Live had gone undercover. It had videotaped two psychics. Now, I wonder how good of psychics they were if they didn't know that there were videotapes. But bottom line, one of them ended up committing suicide by drinking himself to death, and now a wrongful death suit is pending. Oh my, another interesting case that's pending is in Rhode Island. A man by the name of Clift decided to commit suicide. He was serious about it. The police had surrounded the house. They were trying to talk him down. He was firing guns and all this. The phone rang. It was an enterprising reporter from Channel 12 calling in to interview him without permission from the police. She told viewers, 6:04, the report started. It's obvious we're dealing with a very troubled man. What you're about to hear is a man who is angry at the world and could be on the verge of suicide. And she gave him his chance to say goodbye. And at 6:07, the police heard a gunshot. He had killed himself. The police rushed in, and every TV was tuned to Channel 12. That suit continues. Well, we've had some interesting summary judgments that have come down in some kind of collateral fields. Hitman, a technical manual for independent contractors, followed all 27 steps in killing 3 people, but an escape there. Oliver Stone, how many saw natural-born killers? A miss on that with a summary judgment for Oliver Stone, the defendant, after a copycat case where a 37-year-old now remains a paraplegic. The Jenny Jones case, we've got a $25 million suit there. Jenny Jones, Jonathan Schmitz killed Scott Amadure, and it keeps on going. Well, I will close with mentioning an area that concerns me, and that's the tabloidization, if I can use that word. The Giffords forced tabloids' hand, AP. The oh-so-lovey-dovey image of Frank and Kathy Lee Gifford was shattered yesterday when a supermarket tabloid released a photo claiming to show him groping a blonde in a hotel room. That's the AP. We have Time showing Pitt's parts, Brad Pitt, his head on top of a naked statue because of a case that had involved Playgirl. Yep, I'm gay. Time. How do you separate that from Inside Ellen's Love Nest? I don't know. On and on. I guess one of them that I really like the most, Marv Alpert. And what have we got here? We've got Time, and we have got all the tabloids down here. Menage a Marv. Marv bites back. The night Marv flipped his wig, and Marv gets pink slip. Where do you draw the lines? Well, so many bad examples we could use, but right now I want to sit down and hear what the journalist has to say.
Well, hello. Okay, first of all, I think most of what you just heard from, with all due respect, these are not at all examples that exist in most day-to-day real world of working journalists. These are so extreme that you trivialize even the kind of what I would think would be a healthy discussion of the subject. But, however, I want to talk about some of this because I think one of the reasons that the press gets a bad rap is that people I think that sensationalizing even a sane discussion about the news is almost as felonious as the conduct that you accuse the press of becoming. But let's think, in both examples that we have had from the two previous speakers, what is the common theme here? Most of it is that you're talking about TV. There is a vast difference when you have a discussion about the press between the needs of television and the needs of a print reporter like myself. Okay, I've been watching TV reporters for a long time, and I respect a lot of what they do, but they have a need that I don't have, and that is that they have to have pictures to tell their story. I could have done a Food Lion story probably just by interviews. I could have interviewed people who work there. I probably could have put something like that together. I didn't need the pictures. So let's put that aside. And when we talk about ethics, let's not talk about the extremes. And also, I don't consider Jenny Jones, by the way, a journalist. Okay, you're talking about something else. If you want to talk about talk show ethics, fine. I don't know about that. I think that there are times where you have big questions, okay? I don't think I can't say to you that I'm an absolutist on all these ethics, but I could tell you that 99% of the time, I don't lie, I don't pretend, I'm straightforward, I'm transparent. I'll even, if you're not someone who deals with the reporter very much, I'll even remind you as we start, you know, what you say to me, I'll write down and it could end up in the newspaper. So think about it. Okay, if you need a minute to think, think. Because what you say could end up in the paper, it might have ramifications for you. I have no problems telling people, warning people. It has never hurt me. I've never not gotten a story because of that. And you know what? A lot of the things that, again, are these examples of the extreme, let me call them, are not routine. But there are routine problems. Let me tell you a few stories. Just recently, you know, sometimes people just don't understand that reporters could get stuff going through the front door and doing things the right way. Investigations are very sensitive. I've been doing a lot of coverage of the Senate campaign finance hearings, and I was particularly interested in knowing if one person or another who might have particular connections was being deposed by Senate investigators, and they were being very secretive about it. Now, I did get a tip or a suggestion that maybe somebody who I was interested in might be deposed on that particular day. Okay, that's all I knew. I knew the name of the person, and I knew this person may be deposed. But you know what? That was a good enough tip for me. Now, maybe some people could just make one phone call and someone confesses just out of some kind of either pity or need to talk too much. What I did is I went to some sources I had, and I said, where do people get deposed? I had a list of about 5-6 places. And then I did what I always do, which is you do the most obvious thing first, which is you go to the closest place. I was in the Senate Hart office building where the campaign finance hearings were being held. And I just went to the place that was closest in the building, and there was an office there that they used. And then, this is where dumb luck played a role, I misread a sign. It was one of the lawyers' offices, and I thought they said, this door closed, go to the next door. And it kind of, when I went and looked at it, it's not what it said, but that's what I thought. So I opened up the other door, and you know what? I walked right into the deposition of the person I wanted. We all stared at each other. It's clear that the person knows, and I knew who she was. She knew me. After we stared at each other for a very long moment, and she said, hi, Lynn. I said, hi. I left. Both lawyers came flying out, and to this day, they don't believe that somebody didn't drop a dime and just, steer me where to go. So sometimes, you could do things the right way. You don't have to do things the wrong way. But it's a tough job. Every day, I deal with people who routinely mislead, omit, lie, or somehow cheat on the truth in what a conventional person might tell. But that doesn't mean that I do the same, okay? Because in the end, if you want to get the story right, you have to make sure that you're not misunderstanding people, you're not putting out questions that aren't what you really want the answer to and you put something else. I just don't think that has to be done that way. And you know what? I don't want to do anything illegally. You could walk up to a line. It doesn't mean you cross it. I'm trying right now to get information about what's going on before a grand jury. Okay? Well, if you know the rules of who can talk and who can't before a grand jury, then you could figure out how you could find out what's happening before a so-called secret grand jury. You know what? It's not really that secret because some people are permitted to talk about what they know or what they did or who got a subpoena. Those things are perfectly legal, but it takes a little work and you have to know. You know, we were talking about some of the tools of the trade. What's the main tool of a trade of a print journalist? You know, in TV it's called radio. In TV it's called a soundbite. In radio it's called an actuality. In print reporting it's called a quote. You know what we do with quotes? We don't make them up. Period. End of discussion. Okay, the Janet Malcolms of the world, however, of a beautiful point she made about that, and the quote that you gave was perfect, and a lot of journalists quoted about how we're seducers and con men. Well, you don't go to someone and yell at them and expect them to talk to you. And you know what? I am careful to not portray myself as too sympathetic. I don't go to someone and get an interview and saying, I'm going to tell you a story. I did a column yesterday on Kelly Flynn, and I talked to her on Friday. Her press agent said, well, what do you think you want to talk to her about? And I didn't want to, I was willing to lose the interview because I said, well, and also you cannot give away questions ahead of time, but I didn't want to send a wrong signal. And I said, well, I'll probably ask her why she did a lot of real stupid things. I said, because I can, this is to me one of the intriguing parts and why I would want to talk to her. So if he wanted to pull the interview, if I lost it, fine, but I'm doing it the right way. I'm not pretending I'm her girlfriend or something like that, because you know what? I'm not. And the piece I wrote is the piece I wrote. The interview we had is what we had, and so be it. I don't think a lot of these things are all that hard all that time. I don't do a lot of undercover work, but I've done some of it. I had done that. We're going back 120 years. One time I worked with Pam Zeckman when she was at the Sun-Times, and she's a wonderful, wonderful person, and she was doing Abortion Profiteers, a series at the time. And, I was sent to an abortion clinic in Indianapolis where my job was to confirm the identity of a doctor working there. Well, I took with me the urine of a pregnant woman, so I got through all the gatekeepers, and I kept thinking at some point I would meet with the doctor beforehand, and then I would say, are you Dr. Hoo-ha? I'm Sweet from the Sun-Times, here are some questions. Well, it turned out that at this clinic, you didn't see the doctor until you were undressed on the operating table and your feet in stirrups. Well, I figured, well, okay, so I'm there. And the doctor comes in, and then I say, and this is the kind of thing that is food for thought. So when it came to the real point, though, when I got to the person who I wanted to come interview, I said, Doctor, I'm Lynn Sweet from the Chicago Sun-Times. And I think that, there are ways to handle all kinds of situations. And so when the point came that I was talking to the person who I came to talk to, there was no pretense. And I immediately introduced myself, and that is one example of how you sometimes can handle things. You don't have to do the wrong thing to get the right story. And you know what? When I talked about absolutes in the beginning, most of the time you can be pretty absolute about how you want to operate in the business, whether or not you're investigating someone or not. We're not talking about 90% of the time for most working journalists. If you walk into Auschwitz, would you go undercover in order to expose this? Or if you could talk about a death camp in Bosnia. For most of the great issues of our journalists today, it just isn't like that. And I think that extreme situations sometimes do call for different and very perhaps unusual reactions to it. There's a lot of hand-wringing in the business, and one of the things that you do in ethics sometimes is go through in situations where you think you have a problem, is go through the back door. When the Dick Morris story came out, do any of you know who Dick Morris is? Okay, so the story comes out in the New York Post, based on the tabloid. So for the first few hours of the day that the story broke, it happened in Chicago, over at the Sheraton Chicago Hotel where he was staying and where the Presidential Press Corps was staying. There was a lot of hand-wringing because the story's origins might not have been pure. But you know what? In the end, was the story true or not? That, to me, is what you weigh. If something is true, it's true. If it's not, it's not. We have in this business, really, especially print reporters who work solo most of the time. I can't say, well, I didn't want it this way. My producer did it, or my editor did it. Most of the time, I'm working solo. The most I get to blame someone is a headline writer, usually, or an editor. So you have your own credibility at stake, and most reporters don't mess around with it. It's really the only thing you have. If you promise confidentiality, then you've made that promise. But you know what? I don't give promises like that lightly. And that's what I hope you think about in the questions that we might ask in the next few minutes. You don't make a promise you can't keep, but don't make a promise you don't have to make. And if somebody says to you, I can't be quoted, I can't be this or that, then you know what? Maybe you could take the information and not quote them and not use it. Sometimes that's okay, and it's just useful information. Or sometimes you tell somebody, I can't keep this a secret because my editor, this story is so sensitive that I'm going to have to tell someone who I talk to. Okay, but you be upfront, and if you can't get it, you can't get it. I have never not gotten a story because of any ethical problem, and there have always, and that I think is something to remember. If you do a lot of other things, you could sometimes come up with the same result. And many of the big moral issues and ethical issues of our time do have to do with television and their need for pictures, which I think is just a whole, almost focusing on a whole other branch of the business, and is something that is more troublesome often than I think the behavior of print or radio as we look on that. In closing, because I hope you have a lot of questions, most print reporters, as I do, live in a very competitive news environment. And so sometimes you have to be willing to lose a story. Most recently, there was the example of a story that came out thinly sourced and with no examples of how cemetery slots at Arlington Cemetery and other national cemeteries were being sold to donors. Because the Clinton White House has no credibility in so many matters dealing with fundraising, there was an environment where people wanted to believe this story. And in the end, it turned out, as far as we know, not to be true. The first day, it was a little hard to figure out what to do on it, but since the Army and then the White House issued denials, it made it a little easier because at least then you could write about the denial. But I was surprised at how many major organizations made major stories on it. I think it is worthy of a story on how, which in the stories came out yesterday and today, of how a story that apparently had no substance to it got picked up as much as it did. And a lot of that has to do with the strength of talk radio, but we're not talking about that right now. So I hope you have a lot of other questions, and just remember that in the daily journalism, at least that I work in, a lot of this is not abstract. It's real, and it happens when you're juggling a lot of stories. I'm usually working on anywhere from 2 to 5 things at one time, and there just isn't a lot of hand-wringing going on. So if you have, I think, kind of a set of operating principles, the rules of the road, it's not that hard because, as Mike pointed out, we're not licensed, we're not regulated, we have no professional code, and no one who's apparently, no one who has any kind of regulatory or supervisory legal will over the press. Thank you.
Well, I don't think I'll take too long. For those of you who are late, before I was editor of the Daily Law Bulletin in Chicago, Illinois, I worked for the Sun-Times and the Tribune, and I was involved in a lot of projects, and a few of them won the Pulitzer Prize. And through the years, I've adopted the attitude that the responsibility of the news media is to get a story wherever they can get it, however they can get it, and print it. And if the story is true, then they won't get in trouble. And if it's not true, they're going to have serious problems. Now, some of the things that you heard today about these outrageous examples from the Food Lion case, which was an undercover investigation that went awry, Whatever happened to ABC on that one, they deserved, because they didn't do their job. I feel the same way about CNN and hooking up with an ambitious political U.S. attorney who used them and created a mess for CNN in the process. Well, whatever problems they brought on themselves, that's their problem. Good luck to them. The one place that you really get found guilty of in American society today is the lawyer, your lawyer. He makes you pay dearly when you're wrong, because by the time he's done running up the appeals, a meaty case that would involve the Sun-Times, when I was still at the Sun-Times and went on after I left, involving a politician who sued us, it cost the Sun-Times almost six figures for him to get the case to discovery and then drop it. And his intention was to make the Sun-Times pay for the story they printed, and they paid with big dollars to a very expensive lawyer who did a terrific job of defending him. And so that's sometimes, I think, the place where you really pay the most. And unfortunately, it also continues to prove the premise that the rich get get better protection than the poor. Any of you who saw the O.J. Simpson trial can't argue with that point. But let's go about some of the things that the press is being accused of, and which Mike has made examples of, and that's the undercover role of the press, which is it's terribly wrong, it shouldn't be done, and it really went out of favor in print when the editor of the New York Times and the editor of the Washington Post, Abe Rosenthal and Ben Bradley, ganged up at the Pulitzer Committee on the Sun-Times because they opened a tavern called the Mirage and ran it undercover for 3 months with a bunch of reporters and some people from the BGA and then later some people from 60 Minutes, and showed that city inspectors, fire inspectors, were corrupt, and for $50 they would look the other way. They didn't care if the electrical outlets were sparking and if everything was going on. As long as the money was, they were getting the $50, they went away. It was a terrific project, and it was up for the Pulitzer Prize. And Ben Bradley of the Washington Post and Abe Rosenthal of the New York Times said that this was bad journalism because it was undercover journalism, because the media misrepresented itself. It presented itself as something other than the media, and that was wrong. And so they argued very strongly against the Sun-Times getting the Pulitzer, even though the committee that had reviewed all the investigative projects had sent the Mirage story in as the #1 project in the country, the Sun-Times project, which, by the way, was a Pam Zeckman story, and she stole it legitimately from the Tribune. The Tribune wanted to do it, the reporter, and Pam was working for the Tribune at the time, later moved to the Sun-Times. Tribune wanted to do it, but the lawyer said, no, you can't because of the Dram Shop Act. Somebody gets drunk in your tavern, goes out, smashes up, the Tribune company will be liable. So the project wasn't done at the Tribune. Pam Zeckman left. The Tribune went to the Sun-Times, went to the publisher of the Sun-Times, Jim Hogue, said, I want to do this story. He said, that's terrific. He helped her buy the tavern, and the rest is history. And I'm not saying anything against Pam because Pam wrote a book about it and told the same story that I just told in print, so it's not some insider thing. The Sun-Times story was terrific. It deserved the Pulitzer Prize. I was sitting at the Tribune at the time. I hated the story. I thought it was scum because I didn't have it for myself. And you had this curious development of the editor of the Chicago Tribune, Clayton Kirkpatrick, vehemently defending a Sun-Times project for the Pulitzer Prize when he knew it would hurt the Tribune to have his competitor win the Pulitzer Prize. And he lost out to A. Rosenthal and Ben Bradley, two terrific editors and two men I really admire. And A. Rosenthal thought that was wrong. However, that didn't prevent him from violating the National Security Act and printing the Pentagon Papers. And that was okay, I guess, to violate national security laws, but it wasn't okay to go undercover. I've always wanted to ask him how one is okay and the other isn't, but I've never had the opportunity. In both of the cases, those two examples that I gave, and I'm going to use some more, what ended up in the end is neither place got in trouble, although the New York Times was shut down by an illegal prior restraint by a brilliant federal judge, right? Yeah. So here was a brilliant judge who shut him down with prior restraint against the law, against the Constitution. But he pulled it off until The story then got leaked to Ben Bradley at the Washington Post, and he thought it was a terrific idea to violate the National Security Act and several federal laws and print the story. And because the story turned out to be true, they became people to be admired rather than people to be sneered at. Now, they also went about it in an ethical way, unlike some of the examples that have been used today. And Ben Bradley, if I can continue the story, who, as I say, I have a great admiration for, and Ben is a very ethical journalist who, other than printing national secrets, also feels that you should never get involved with law enforcement in any way, shape, or form when you're doing your duties as a reporter. You should never be in any way involved with law enforcement, as CNN tried to and very unsuccessfully failed to do in the example that Mike used. I generally agree, but I think there are times when you bring law enforcement in, when you're doing an investigation, if you're finding that people are breaking the law. And the reason I think at some point you might want to let them know, maybe it's even the day or two before the story prints, so that they open their investigation and they have some sense of what's going on. Now, Ben Bradley didn't think that was a good idea to have anything to involve in law enforcement because it hurt the purity of the press and it was unethical. So what he did instead was have a young reporter work for 4 months with a 9-year-old heroin addict who was being victimized by her mother's boyfriend and her mother, and turn into this heroin addict, and have this story appear in the Washington Post, never telling anybody in law enforcement who this person was who was addicting this child and who the people who were involved, so that the day that story broke, the police couldn't have gone and arrested this fella and brought him to justice, and because he didn't have anything to do with the law enforcement, because that was unethical. And unfortunately for him, because he didn't do any of these things, he discovered after winning the Pulitzer Prize for the story that the story was untrue and that none of it ever happened. None of it had ever happened. It was the fiction of a reporter who was very ambitious and wanting to get ahead and just made it all up. And because there were no checks and balances on her, there was nobody questioning her other than her editor, she got away with it. And they printed this story, won the Pulitzer Prize. Then Ben Bradley, they had to turn around and give the Pulitzer Prize back. Now, if he had at any point along the way asked that reporter, does Sergeant O'Shaughnessy have any idea about what's going on, or that this fellow has a record, or that he's going to be arrested the minute this story breaks, if he played any kind of good citizen role, forget about good journalist role, the story never would have printed because the poor reporter would have never been able to involve law enforcement because it was a fiction from beginning to end. 3 projects that I was personally involved in that won the Pulitzer Prize involved undercover reporting. One involved a hospital out in the South Side that's long gone, in which the doctor was a private hospital owned 100% by a doctor, and this hospital was doing wholesale operations on families, poor families, obviously, and they were getting, state money. They were getting welfare money. It was a terrible place in the hospital. We had no way of knowing, other than anecdotal material from people whose credibility was somewhat in doubt to begin with, what was truly going on. So we made a decision to try to get inside the hospital, and a reporter who has since gone on to win 2 more Pulitzer Prizes in addition to this one, got a job as a janitor there. And one day he was washing the halls outside the operating room, and he was called into the operating room. He didn't know why. He assumed that there was some mess in the operating room that they wanted him to clean up. And once he was inside, he was asked to help move a patient who had been operated on from the operating room to the recovery room. Now, he's a janitor. That obviously, when the story was ready to write, was the lead of the story. And it was devastating to the hospital. The fellow who owned the hospital, doctor, closed the hospital rather than face all the investigations, because we had all the other factual material that you can get from state records along with it. And we closed a very bad hospital. It was an undercover reporter who I would say did a very good job. And under the right set of circumstances, I'd be happy to do it again, because I don't think he did anything wrong. The owner of the hospital had brought in a press secretary and a press agent to try to give him some good press, and he was a fellow I grew up with, the press secretary. And months later, he told me that the owner of the hospital said the reporter was a low-life son of a bitch, but boy, was he a good janitor. A year or 2 years before that, when the Tribune won a Pulitzer Prize for vote fraud investigation, they had a reporter working in the county clerk's office. And every night he stole petitions that were signed by Chicago voters, allegedly, and brought them over to the Tribune, stuffed them in the crotch of his pants, and he brought them over to the Tribune and had them photographed because they were all phony nominating petitions. They were round-tabled by precinct captains, and he brought them over, photographed them. That's theft of property, right? When he got his job, he had to lie about who he was to get his job in the clerk's office, and he got his job because he had a terrible source that was a Republican in power who wanted to embarrass the Democrats. So he violated about 6 ethical rules, I would say, right there, Mike, or at least 4 so far. Right? And he worked in that office through another Republican, because we're talking about Chicago Democrats, through another Republican, a bunch of reporters were signed on as judges and election watchers and what have you in various precincts in Chicago, all undercover, none of them representing themselves as Tribune reporters. A series of stories were written after the election. Months later, the indictments came down, and it was based on this, and Jim Thompson was U.S. attorney at the time, and he said it was that the Tribune investigation that did go on to win a Pulitzer did more to counter vote fraud in Chicago than any project he'd ever been involved with or any project he'd ever heard of his entire life. There were 78 indictments and 76 convictions. That was an undercover job of reporting. Would, if the right set of circumstances existed today to do it again, certainly. Last story, unfortunately it's true, there was a hospital that opened up in Chicago, and it was opened up to allegedly to treat DUIs, not DUIs rather, but people who were alcoholics. And they were state financed. And what they would do, what we heard from the outside, was that they would just go down to Skid Row and get people into their van, take them to the house, to this hospital up in our side, warehouse them, and do nothing for them, and basically put them in restraints if they went through DTs or anything else, keep them in there, and then charge the state the maximum amount of money, and dismiss them actually weeks before they kept charging the state. I mean, they dismissed them long before they stopped the charging to the state. Now, we decided that we were going to take a look inside and see if it's true, and the way we're going to know if it's true is if we actually experienced it. So a reporter on my staff, fellow Irishman like myself, he was a natural for Skid Row, asked him to go down there and to take an apartment in Skid Row and to basically get half hammered before 10 a.m. in the morning, and to make sure that enough people knew that he was drinking. And that's what he did. And he became a regular, and he became somebody that was identified as potential treatment subject. And they one day asked him if he wanted to get cleaned up, and he volunteered, and he went out there, and he lived in that place. And it was a horrible experience for me. He used to get one phone call a night, and he would call me. I was the city editor at the time, and he could only take it for about 5 or 6 or 7 days. When we ended up pulling him out, and the hospital charged the state for 3 months of treatment on him. And they did everything else under the sun that was terrible. And what we had was somebody who had experienced it, who had lied about who he was, and who had misrepresented himself, and who closed the hospital. And the Pulitzer Committee thought that work was good enough to give the Pulitzer Prize to that effort. Now, what I think happened on this undercover journalism for print was that the 3 Pulitzers I'm talking about all occurred prior to the Mirage Tavern, which was my first example. And what was happening is on in New York and in Washington and the East Coast, that Chicago was winning too many Pulitzer Prizes. And so a great ethical dilemma got raised to prevent Chicago from winning any more Pulitzer Prizes. And before right after the Pulitzers were announced in the Mirage Tavern, Pam Zeckman didn't get it all, she well deserved it. A front page story appeared in the New York Times discussing the ethical issue of undercover journalism, and Pam Zeckman's role in the Mirage Tavern was one of the prime examples of something that journalists shouldn't do anymore. Now, it makes me sound like I'm thinking conspiracy here, and I would never want to do that in this forum. But again, I'll state what I said when I began, that I think our job of a good journalist is to find the news wherever it is and then to print it. And if he's telling the truth, he'll be okay. I say he, I mean she and he. He'll be okay. And if he doesn't tell the truth, he's going to be in a lot of trouble. And I want to talk just for one moment on what Lynn said about a promise. Journalists, that St. Paul paper promised somebody they wouldn't use his name, and they wouldn't use him as a source if they printed the information that he gave them. And then they turned around, because he was kind of a kinky character, and printed his name, and they broke the promise. And then they were sued for contract violation, and they were found guilty, and I was really happy that they were, because I thought they had it coming. I think in journalism, if you give a promise to somebody, even though you shouldn't have given it to them, you got to keep it. Because I think the public has to believe that if you give a promise, you're going to keep it no matter what. And if you look at the end of Richard Nixon, they began there. Ben Bradley, who did a great thing, he basically lived off the promise of Deep Throat that they would never say what his name was. To this day, we don't know who the source of the material was that began the snowball that destroyed the President of the United States of America. Ben Bradley alleges that he doesn't know who it is either. I've never believed that, but that's what he says. Now just imagine if our strength, our credibility with the public gets ruined because people willy-nilly break their promises. So when somebody views an oral contract as lawful in the media in giving a promise to a source, I'm more than happy to see them pay a price for breaking that promise. More than happy to see it, because I think if we don't have credibility, we have absolutely nothing. And now I'll be very curious to see what you folks all have to say in the way of questions, and I'll sit down, and thank you very much.
I want to thank all the panelists for a very comprehensive discussion of all the issues, I think, and that, as I had hoped, presented all the different perspectives. We would like to invite anybody who has a question or a comment to come to the microphone and do so. We ask you to come to the microphone because we're making a video so we can complete the program and send it out, and we need to record your questions. Professor Thoreau.
Thank you. Mike Polelle asserted that the media has no license, it is not regulated, and it has no professional code. Lynn Sweet agreed to that. I found that rather astonishing, because my understanding is that even the mafia has a code of conduct. Now, she talked about the fact that these extreme examples, Ms. Sweet said these extreme examples that Sandra Davidson brought up trivialize the discussion. Now, I would assert instead that they define the discussion, because, as you also pointed out, it's a highly competitive business. And it appears that since the Supreme Court has opened the way in the Sullivan decision and its progeny, that the media, in fact, has tended to constantly move toward the lowest common denominator with respect to performance. And I would make the charge, and I would be interested in your response to this, I would make the charge that, in fact, the media is hypocritical. The reason it does not have a professional code is that it does not want one. It does not want anything to stand in the way of their getting any information that they decide they want to present to the public. What do you think of that accusation?
Can I add to the accusation? How about the fact that they don't want an ethical code because it would create standards that could later be used as standards of negligence against them in courts of law?
Well, I'll tell you, I'm not going to rise to the bait. First of all, the media isn't monolithic, okay, and it does not. There is not one. It is in many mediums, and again, I think that there's confusion between news entertainment and what is the traditional news reporters who have news shows or print articles or radio broadcasts based on, kind of traditional news reporting and not going into the infotainment. And, the idea with regulation is that you don't want there's no reason to put any restrictions on news gathering. I just don't think it has to be made all that complex. And that is why I what was the first part of your question, Professor?
I was simply laying the foundation for the
Yeah.
accusation that you really don't want codes of ethics, and that you, in fact, are hypocritical in the sense of maintaining
that's it.
that there's decency in part of the press.
Well, first of all, decency is too. That's not a kind of a word that I think to work with. I think you need your credibility. See, every time I write a story, every time any reporter goes out, anytime any editor lets a story out, and no matter what medium, if you lose your credibility, you've lost your ability to tell a story. And that is a very high self-regulation to me. It's incredible what you do to maintain credibility in this business. And I don't know what it would be like to live in, as some countries do, where journalists actually are licensed and newspapers have licenses, okay? But what we trade on is credibility, and when you lose it, it's as bad as if you've had your law license revoked, except there's no appeal, and you can't just suspend it, and you probably can't get it back.
May I put on a different hat, literally? Rather try to defend the media.
Why a black hat?
Because it matches my jacket.
Oh.
Okay, Oliver Stone, Hitman, Jenny Jones, I mentioned those as peripheral cases. But everything falls under the umbrella of the First Amendment. In the wake of Princess Diana and her death, and I've been collecting cover articles on that. We had a lot of the photojournalists at my school who were very upset about why don't people draw lines between the legitimate photojournalist and the paparazzi. And of course, the question becomes, where is the line? But in law, often it is the bad examples that make the case law. I'd just like to read one comment from News Photographer magazine. Got a picture of Princess Di on the cover. A friend, a Daily News photographer, was on assignment when cops began to heckle him. "Hey, paparazzo guy." He responded, "Don't joke with me about paparazzi unless you want me to joke with you about plungers." In short, in every profession, you have people at one extreme operating under their own personal codes that are impeccable. And then you have the people at the other extreme.
Remember, I said I'm not an absolutist. I did say that.
But you are impeccable.
No, no, only human and with much humility.
I will admit, though, I am going to imagine you in my mind quite a few times talking to that doctor, and I don't see how you could have had the grace under fire. That's an amazing story. But you have people at one end of the extreme, and then you will have people at the other end of the extreme, and it's often the lower level that ends up making the case law.
Anybody, you can just walk up to the microphone and I'll recognize
Wow,
you.
you can just walk up. Hi, I'm Walter Kendall. I am a professor here also. From what gets into the newspaper perspective, I do a lot of work with community groups and social change organizations. Lynn and I were talking at lunch about my wife, in fact, and some friends. And it seems to me that who Marv Alpert is doing whatever the heck he was doing with, and all of that is much less urgent and newsworthy than some of the things that some of the groups that people like Gail Sincata works with and others, and they clearly do not get an appropriate amount of attention in terms of their value to society, if I can be so bold as to speak in those terms. And so I'm curious as to what the sentiment of reporters and professors and editors and publishers especially, in terms of what you really mean by newsworthiness. I love dirt like everybody else sometimes, especially if it's about people I don't like. I was saying to Lynn that I suddenly find myself having friends who have have become the focus of attention of prosecutors, and it's given me a different perspective, and it's humbling in a legitimate sense rather than that devilish sense that you used the word. So how do you guys decide what really is newsworthy, and how frustrated or troubled are you by the fact that you really did spend a lot of time about the kind of clothes Marv Alpert wears when he's biting people of the opposite gender?
Well, if newspapers and I think news shows try to reflect a lot of different aspects of life. Okay, look, that's why we have sports sections. That's why a lot of time is devoted to weather on TV. That's why you have life is not all just government and politics and civics lessons. And one of the things I think sometimes newspapers can do is get inside a story and behind a story. If the biggest problem I think facing the press in the United States is whether we covered or overcovered the Marvin Albert story, I would think we're in pretty good shape. And that was the most pressing ethical dilemma facing us, because sometimes some stories exist and we do pay more attention to them than we should. Who didn't read a story about Lorna Bobbitt and her knife? Are we overcovering the septuplets last week? Now there's one where I think, if you talk about just coverage and decisions and getting on a kind of a giddy bandwagon on it, and I think in a few days or weeks, the press will self-correct on that one and have even more weighty articles about ethics. And maybe you shouldn't have more babies than you can handle if you can't afford. And I bet you will see a change. And so there isn't any manual that's put out that every day provides, that absolute guide as to what the ingredients are, what the menu is. It just depends a lot on the mix of the day.
If I may make an appeal to authority, the Restatement Second of Torts, which is often adopted by courts, says this as a definition of newsworthy, quote, authorized publicity includes publications concerning homicide and other crime arrests, police raids, suicides, marriages and divorces, accidents, fires, catastrophes of nature, a death from the use of narcotics, a rare disease, the birth of a child to a 12-year-old girl, the reappearance of one supposed to have been murdered years ago, a report to the police concerning the escape of a wild animal, and many other similar matters of genuine, even if more or less deplorable, popular appeal. So that's a guideline to journalists.
Yeah, but how does Bernie live with himself?
Easily. A newspaper is a journal of the day's events, and it's not all significant. Except at the Daily Law Bulletin or Chicago Lynn. But it is a journal of the day's events, and what people talk about. If you ever watch people gossiping, you know they're gossiping from 40 yards away, because you can tell by the intense, fascinated look on their face. They're always kind of close and they're listening really carefully and they're being quiet. Well, a newspaper in some way reflects that. It's what happened yesterday in town, and town's gotten to be a rather large place, which is one of the problems that journalism is having with all of these ethical issues is that television doesn't serve an audience of 100,000 or 200,000. It serves, tens, hundreds of millions of people, and if it's big enough, it's almost billions of people. And television is redefining all of
as is the internet, which we haven't even gotten to.
Yeah, it's redefining it. When I got into journalism, the newspapers in this town were the compelling news source, and they're not today. They're the second source of information, not the first.
That's one thing I wanted to add. It occurs to me. You stop to think about it. The medical profession has always been very high in public esteem. Lawyers and journalists are down at the bottom. And what intrigued me was this recent law that was passed by Congress where we're now paying medical schools not to take on new applicants. Seemed to be very little public debate. But look at journalism and law. You know, we're very competitive. We put no restrictions on entry. Apparently, you don't even need a degree to be a good journalist. So we encourage competition. Now, the problem I see is in the long term, in the short term, for the unscrupulous, there's a kind of advantage. It's like you go to a toll booth and the guy comes ahead of you, go first. If everyone stood in line, it'd be better for the ultimate interest. But for the guy who's cutting corners, there is a short-term gain, I would imagine, in getting a scoop. And that's the old story. Good money drives out bad. And it's the long term that bothers me. I mean, doctors are protected in a way, so they don't have to deal with these competitive problems, which amazes me. But I think it's these competitive pressures that are going to cause problems long term for both professions.
Let's go to the back.
He was ahead of.
Oh, okay.
This is for Ms. Sweet or anybody who wants to answer. I'm Joe Slovenek, an independent thinker who voted for Jerry Brown for president. Do you think the coverage of Whitewater was fair, or did it unfairly detract from Clinton's successes on the economy and education legislation in 1993 and 1994? By the way, I do want the news media to know I never received a salary from the government during the Clinton administration, but I still desire fairness in news coverage of the Clinton administration. So that's what the question is.
Well, here's an answer. An answer is it depends on what you read. If you read every day the Sun-Times, the New York Times, the Wall Street Journal, and every week Time, Newsweek, and U.S. News, if you watch the news every night on the major news networks, CNN and C-SPAN, then I think you would have a very balanced coverage of the Clinton administration, the good, the bad, and the ugly. If you watch the Whitewater hearings when Senator D'Amato was running them, then you could have been in the room and have heard a lot for months on end about it. So it's like everything else, there's not one answer on it. I think if people have an interest in a particular topic, they have to take some responsibility and not expect that on any day that they have it all laid out in front of them in one neat place. You've got to do a little work. So if we want to have an intelligent discussion on Whitewater coverage, we'd have to go back, let's look at the stories, let's measure them, let's clock them, and then we could talk. And I think one of the things that bothers me is that so much discussion about the role of the press it has to do with perception rather than a fact base in dealing with the substance of coverage. But overall, the press gave enormous coverage to Whitewater. Whitewater got started in the press, just as the campaign finance story got started in the press. And while Clinton has been the beneficiary of some very good stories, especially in 1992 when he first ran, he certainly has been the subject of some very negative stories, as has the First Lady.
Okay. Back.
When it comes to breaking a contract between a client and the attorney, I'd like to know how much of it has ever reached the highest levels so some censorship and withdrawal of license can be done. I've yet to see any of it in print or in fact, as opposed to a reporter who will lose their credibility and eventually lose their job.
There's a case in downstate Illinois where a lawyer's been suspended for breaching the
A lawyer. How many cases are there?
That's
And
one I know of.
yeah. It rarely comes up because it doesn't get up too high. And I don't see any of the legal people up at the panel able to respond to that.
Well, no, I'd respond very easily. I think that another lawyer would sue for a breach of privacy.
Of course.
Yeah.
Another
Lawyer or
lawyer.
journalist should be the same.
No.
I agree with you.
No, but I'm talking about
question
breaking
seems to
your
be-
word with your client.
You know,
The question also seems to be, why isn't that covered more in the press? Why don't we hear about it?
I don't know. Maybe the press
No,
people
no, no,
could
not
answer.
out of the press, but out of the legal profession sending it into the press.
Well,
Mr.
maybe
Welch,
I'd like to take the optimistic view. Maybe most lawyers don't break their promises to clients. just as most
You
journalists
wouldn't
don't.
want to hold your breath on that one, would you?
No, actually, I do. I think most of the people I know as lawyers, I think are pretty ethical. I would hold my breath on that one.
You're not their clients.
I would say that in Missouri, we do have a publication that comes out periodically that does list disbarments, it lists reprimands, and I must admit that I certainly do read through that list to see if it's any of the lawyers that I know. So,
I don't know of the ISB or the CBA ever putting a list out that way.
Well, we print all of the suspensions, disbarments, what have you, censorships, and what the example you're using is a. It doesn't happen very often that it ends up as a complaint before the attorney, registration. That is because people don't complain about it, and I don't think, quite frankly, it happens all that often to begin with. I do know that lawyers very often break some client relationships when they talk to the press, and I'm glad they do because they feel a greater sense of what's important for the public to know. And I would say that it's happened in my career several times, and I'm glad it did, and I hope the opportunities continue. It's a problem for the lawyer if he gets caught, but he's not getting caught as long as he talks to me, and that's the way it goes.
Kind of on a related matter, in the McVeigh trial, there were some statements apparently that came out of McVeigh's lawyer's office, which seemed to be at some time a confession or some damaging statements. And I wonder what your thoughts are on the using of those statements and possible risk to fair trial.
Oh, that was it, because this is the story, if I remember correctly what you're referring to, that the Dallas Morning News had, and they not only had it, but they were so happy they had it that they scooped themselves and put it on the internet edition of the Dallas Morning News rather than even wait to print it because they thought they had such a scoop on their hands. If a lawyer, that is a kind of story that is more the lawyer's problem than the reporter's problem. If a lawyer came to me and gave me information that was credible information and newsworthy,
Mm-hmm.
I cannot see any reason not to do a story on it. And sometimes lawyers do reveal things that they hope misguidedly, or the stuff backfires because they think it's part of a strategy to help get their client off the hook, or to create a conducive environment to try and get the potential jury pool, more sympathetic. But when you play with fire, you get burned. And I don't know the facts surrounding what happened. I don't think the facts ever came out.
I was never sure whether he intentionally did that for some motive or whether it got out and then he
You're all the lawyers, sir. I couldn't quite figure out the strategy on that one of how it helped. But
my understanding of that situation is that a reporter called up Stephen Jones to tell him that this story was going to break about the McVeigh confessions and to try to get a comment from the lawyer. Yeah. And then it became fairly apparent, at least from Stephen Jones' perspective, that maybe that some information would be coming out that he didn't want released, and he conveyed that sentiment to the reporter. And the reporter then, along with the Dallas Morning News, did get this information out over the internet immediately. Instead of sending out the story on a Sunday, it did come out earlier. I think that Stephen Jones' allegation was that the newspaper did so in order to prevent a gag order. 2 weeks later, Playboy also released an internet story on the McVeigh confession using different but corroborating information.
I just thought it was leaked from somebody in his office who was morally offended by the whole thing. I mean, that's just pure guess, John. I have no... But is that what you kind of thought?
I thought, but I couldn't tell what was true from the spin.
Yeah, because the lawyer, Jones, never made a flat denial of the accuracy. Never
If
said
that
it
would
was
result in a mistrial, would that influence the timing of whether, or any part of the decision of whether to go with the story?
I've been in such circumstances where it does play a role in the conversation that you have over whether you should print or not, and I'm sure there's been instances when we decided to hold off, and then there were other times when we decided not to hold off, and it depended on a number of things.
Just tell them about it.
More comments, questions? Professor Nye.
Yeah, I thought this was an excellent discussion. I have just a couple of questions that relate to the basic concept of the seminar, All's Fair in Love, War, and Journalism. I've heard mention made by a number of the media representatives that in one case I'm 99% honest and ethical, and also that I do my best. Unfortunately, as we all know, whether in journalism or in law or wherever, it's that 1% that gets you in trouble. You can be 99% honest and ethical, and the lawsuits against you, the judgments against you, the termination of your credibility can occur because of the 1% lapse. In any event, I've also heard that there's great reliance by the press on the freedom of the press aspect of the First Amendment. So the press wants to obey the law, and yet I see two anomalies. Number one, I hear that there's great pride expressed concerning undercover journalism and the Pulitzer Prizes that result, the concept of get the story and then let the police know about the wrongdoing, instead of informing the law enforcement authorities, letting them do the job of enforcing the law and developing evidence. And then you can write about what the enforcement authorities have found. In my view, it appears, and from the stories that some of you have told, that undercover journalism often prolongs the wrongdoing that law enforcement authorities could take steps to stop immediately if you or others simply let them know about the alleged wrongdoing. And secondly, I'd like to know a little bit more about your views as to the duty to obey a court order to reveal your source when you've made a promise to a source that you're not going to reveal that person.
Well, I want to clarify, since you on the point that you brought up, since it did seem directed to me. I think that you have to. I think absolutism as a rule is sometimes just too absolute. So that's why I left the door open for a set of circumstances on a day I can't imagine right now, in a place that I've never been at, where I might do something, where I might make a judgment call different than I do in my workaday life, where, you know what, by the way, and without, I think I am very consistent in how I operate. But I think one would be a fool to say that you operate all the time in one way, because there might just be a fact situation where something that I can't even imagine right now for a hypothetical, I might act different. Each day, as Bernie said, we just try to tell the story of what happened yesterday, and each day brings something new, and you maybe do look at something differently. And I want to clarify that, because I think it's important, and it doesn't mean that you leave 1% open just to have some wiggle room. And your point about why don't you just call the cops or the authorities and tell them something's going on, that's not how the real world works. It just isn't how it works. And you know what? If you just call up right now, if you say, I hear there's a hospital that has a lot of unsanitary and unhealthy practices going on, no authority is going to necessarily act on that or make it a priority or do anything on it if you have no more information. One of the reasons I think that the points Bernie was making is that you try and get some facts out there so then a law enforcement body or someone can act.
I mean, it really is true that people don't look in law enforcement and other agencies, don't look for things to investigate, because most of the time they're consumed by the things they have to investigate. And so if they're not willing to be aggressive, then a lot of bad things continue to occur. Now, the examples I used are all back in the 70s and early 80s, and I haven't practiced that type of journalism in recent times, but I just don't think it's a good idea to say it's bad. I think there might be a set of circumstances where it would be appropriate. And I don't think you should close the door, because I think that you never know what's going to happen. And back to the 99%, I mean, I think if she said that she does the right thing 100% of the time, we should call her God. You know, I mean, it's just, or, well, I said her God. I just don't think you can do that. I mean, she's not saying that what she's saying is that she's going to make mistakes. Maybe you don't, but I do. You know, you make mistakes. If you're batting, you know, they pay baseball players millions of dollars to fail 2/3 of the time. You know, if you're trying your hardest, you're gonna bat pretty well, but you're not gonna bat 1,000. You're just not. I mean, you're gonna do some things you wished you hadn't done.
I believe the question also related to, would you reveal sources to grand juries? On revealing sources, I believe now 29 states do have shield statutes. I've also heard them compared to insurance policies. They tend to cover everything but what happened to you. Currently, the record for days in jail by a journalist is William Farr, 46 days in the Charlie Manson case for refusing to reveal who the prosecutors were who had leaked information to him.
And that prosecutors knew, and they made him try to reveal it because there was other prosecutors in the office. And he refused to reveal, so he's being prosecuted by the prosecutors who told him the story. And he refused to reveal their name, and he did 46 years in jail for it. 46 days, excuse me, 46 days in jail for it. Years, that'd be a hell of a story. Name would be Mandela. I mean, he did 46 days, and he was being prosecuted by the prosecutors who gave him the information. And he was protecting the people who were prosecuting him. But he did that because he gave his word. I always thought he did the right thing, and he knew he was going to go to jail for it, and he did it anyhow.
I think that it's important for journalists to consider how far they would go in protecting sources in terms of, would you go to jail and how long would you stay? In part, I think it might depend on who your cellmate was.
Yeah.
But it would be a very difficult decision.
I have asked that specific question on projects when we've had sources that could not be named. Are you ready to go to jail to protect that individual's name? And if they said they weren't, then I said, we better figure out another way to do this story. Yes. You know, because we're not going to sell them out. Mm-hmm. Once we print, they're going to be protected. So we'll have to find another way to do it. Anyway.
I'm Donald Morano, an attorney in private practice, and I guess in some ways I was a little disappointed. I guess particularly by Ms. Sweet, because it seemed you seemed so assured that you always make the right decisions, but you didn't tell us what the principles were that you were using to make the right decisions. And I think that was in some ways what Ms. Davidson was saying. Also, it seems, Mr. Judge, that you certainly felt that these Pulitzer Prize winners were great, but you seem to think that somehow that the Food Lion case had gone beyond the pale, and it seemed to me that the Food Lion case was just an absolutely appropriate form of undercover investigation. And I would propose for a discussion in this short period left that there should be unfettered, undercover reporting allowed by the news media as long as there are no laws that are being broken. And if the laws are being broken, then of course these people are subject to prosecution just like anyone else. And the second point that Mr. Bernabe, that's your name, at the beginning, it seems to me, unless you have such a thing as Janet Malcolm, where you have this long-standing misleading, and of course I represented Brett Kimberlin for years, and Mark Singer in his turnaround misled Brett right to the end, and I knew this was happening, but he wrote the New Yorker article in 1992, in which it was almost hagiographical, it was almost making him into a saint. And then at the end, he makes him into a villain and a murderer. And Brett didn't know this until the 1996 article came out. 4 years later. So, but what I'm saying is that shouldn't in ordinary journalism, why would you have to reveal that you are a journalist? I don't know that, particularly if you can't get the information. As long as you're not doing something as the examples of Miss Davidson, where you endanger people's lives.
Well, I want to go back when you talked about. I wish we could roll back to the tape to when I was talking, because when you talked about a lack of explaining some principles, I wish we had the transcript that could just be read back, because I believe I did lay out some very basic rules of the road. You don't make up quotes, you don't pretend who you are, you don't lie, and you go through the front door. And if you have, what other questions do you have? I would like to answer them for you.
Okay, well, I stand corrected.
And why should journalists not, if I could address this, if the others want to, I'll okay.
Sure.
The reason you don't not tell somebody you're a journalist is because of the following. If you're dealing particularly with a non-public figure, I mean, if I go to a press conference and there's a congressman or a mayor or the president, you don't go up and say, hey, I'm here. They know that they have reporters there. If it's people who deal with the press all the time, they know. If I sit next to you on the bus and you start saying, oh, let me tell you, I have problems with my wife, and my boss doesn't like me, and this and this and that and that, and I just went to a store and I shoplifted something. I say, oh, what's your name? This is kind of a nice, sad urban tale. I might write you up. Okay. Does that strike you as a way to operate?
Well, I guess I wasn't listening carefully enough. Okay. Yeah. I guess I know the answer you want me to give.
No, I'm interested in your view. Give me the answer that you want. I don't.
Well, why don't you repeat what you said?
You wondered why we could just go through as reporters and not particularly make a point of saying who we are, who we work for, and all that. If to get a story, why can't we just go operate however we want? And I don't, something, I want accurate information in stories. And as people here who are lawyers or future lawyers or people who might take depositions, when people speak casually, they might not always be speaking accurately. So when I talk to you, I want you to speak accurately. I want your thoughts together. I want, if you have to look up a fact, to look it up. I don't want to put garbage in a story. So there is one, I think, if nothing else, just a very practical purpose, that sometimes people speak off the cuff. If you ask me how much money I have in my purse, I could give you an estimate. I don't know, maybe I have $50, I don't know. Okay, but if it's important, if it's for a fact, we'll look in the purse, get out the money, and count it, and I'll say, here's how much money I have in my purse.
Good point.
So that's what I mean. I mean, so there's a lot of reasons. And also, I have no reason, especially for someone who's not a public figure, to want to trick them. Because people shouldn't end up in a paper through trickery, especially if it's not a hard news story and if it's a feature or something else. And again, I think I said in my opening remarks that especially for people who aren't used to dealing with reporters, I will make sure that they know that they're saying things that could end up in print, and they should take a moment and think about it in case there's any ramifications. Again, and let me just say this, those rules are a lot different. If I'm dealing with an elected official, you are not going to get that kind of treatment. You're talking, the tape recorder's on, you said it.
No, I didn't mean that this would be a natural mode of behavior as a reporter. But I'm just saying, if you were an investigative reporter, or if you as I say, if you were doing a general investigation of a particular thing, well, then you're going to be interviewing different people, and you probably don't want to explain all of that background. That's all.
Okay, and one of the biggest stories I've gotten in Washington was I broke the first story on the fundraise and the selling of access in the White House and the $100,000 dinner parties, okay? I got that story because I just went someplace, showed up someplace, and learned something. And I showed up in a place full of politicians where I was fairly well known. But because I was there and I went out someplace and I saw and something that if you were with me, you would have seen it too, or known it, or learned it. If you knew what to look for, but did I go into this place with the sign, journalists coming, journalists coming, watch out? No. But the story came up nonetheless because it was there to be had.
Okay. I want to thank all the panelists again for wonderful presentations and all the participants for the comments and discussion. We have a reception down on 3E in this building. Take the elevators down to 3. Everybody's invited, and we can continue an informal discussion down there.
Thank you. Good job.